Hello everyone, it's Mark and welcome back. In this video I want to talk to you about getting somebody out of a Baker Act facility after a judge has already ordered them to be detained. So just to go back a little bit over how the whole Baker Act process works, but basically if you've been involuntarily committed, the facility can keep you for up to 72 hours, and after that one of three things need to happen. Either they need to let you go, they need to file a petition to keep you, or they need to see if you are willing to stay on a voluntary basis. Now, I've talked ad infinitum about the whole voluntary Baker Act, and that if you do agree to stay voluntarily, you could be, in theory, stuck there indefinitely. And even if you revoke your consent, the facility can still file to keep you. But even if they do file to keep you on either after a revocation of a voluntary admission or even an involuntary admission, once this case goes to court and a judge orders you to be detained, and there's an order in place, it is very, very difficult to unring that bell. It's really difficult to get somebody out. I'll share a couple of cases that we had recently. We had one where a young lady had been in a facility for 90 days. In fact, she actually went to the facility voluntarily looking for help and got sucked into the Baker Act system and spent 90 days between two different facilities, and they didn't want to let her go. They simply did not want to let her go, and we had I think it was a 4.5-hour hearing in front of a judge, and finally we were able to put a treatment plan together. And the hospital decided at the end of the day they didn't want to continue to deal with the aggravation that I was presenting to the judge. They just simply didn't want to deal with it, and there was a program there that, frankly, if they had not agreed to, the judge would have probably ordered anyway. We had another instance where we had a young man who was in a facility for many months. And despite hiring an expert, ultimately the gentleman had gotten worse. His condition had deteriorated, and it appeared that, frankly, it was in his best interest to stay. So if you allow the state to get a court order to keep your loved one, it's really, really difficult to get them out. And look, we've handled hundreds of these cases by now. I'm always happy to help somebody even after there's a court order in place, but I'm going to tell you, it's a tough road to hoe. It's a stressful journey for the family and for us, which is why I constantly advocate that if your loved one has been detained, the time to fight to get out is right now. Not tomorrow, not the following day, but now, right now. And, as I tell other families, look, if you wait and see what happens, perhaps the facility will let your loved one go, but perhaps, and more likely than not, especially if your loved one has health insurance, they're going to fight to keep them. And if they get that court order, yeah, it's a problem. It's a serious problem, and that court order can be up to 6 months, and it can be extended past 6 months. So anyway, be that as it may, thanks for tuning in. See you in the next video. Bye-bye.